Welcome, everyone. This is the pilot project testing on collections, and this is one of the sessions that we are hosting as part of the ongoing education program, and this covers the basics of each of these items. I'd just like to remind everyone that we are in a webinar, so participants on the webinar are all automatically muted. You can put a question into the chat, and it just simply comes to the host and moderator, and is not broadly shared with everyone. So you're welcome to put questions in the chat, and if we have time at the end, we will definitely get to them. So this session is collections. Many thanks to BFL Canada Insurance Brokers, who provide a very broad level of insurance for all of our members across the province, and we certainly appreciate their support. As I said earlier, it's a pilot project, and we're developing an ongoing 8-part education series focused specifically for Strata Council members and owners, certainly available for new property managers and people who live in strata corporations on the key topic issues. We cover the basics of each of these. There are certainly more complicated issues that arise, but the basics of each of these copies is covered. These are intended for education, not for legal advice. If you have questions and you require some additional assistance, you're more than welcome to email any one of the advisors, and we're happy to help you navigate through some of the issues that you're going through. So we're going to be talking about collecting money or collections, and I have a long list of slides, so I'm going to go through them fairly quickly. And we're going to cover basically the different fees and costs we collect, how we collect them, the types of fees and how they're created, the tools that we can use to collect fees, and the procedures on collections. So the basic objective of strata councils and corporations is to ensure that you collect the money owing to the strata. The money owing to the strata has been approved through budgets, might be a special levy, maybe bylaw fines, maybe lawsuits, insurance claims, could be orders, could be user fees that are associated with property that's allocated to individuals. But we can have a variety of fees that get collected. It's the strata corporation who collects the funds. When the management company are collecting funds, they are doing it as the strata corporation, and they do not have a direct interest between the strata management company and the owners or tenants in the corporation. They, as the agent, are acting on behalf of the strata corporation. So we collect strata fees, special levies, the interest that may be generated on them, insurance deductibles that can be levied on all of the owners. Where there is an insurance deductible as a common expense of the corporation and there's no recovery of it, the strata council can automatically issue a levy for that. An owner debt for damages or an insurance deductible where the owner has been responsible for the deductible. If there's a judgment against the strata corporation ordering the corporation to pay things, such as a human rights issue or a tribunal decision or a court action. Any order under Section 84 or 85 of the Act. These are work orders, and they're issued generally by a local government, the fire marshal, building inspector, those types of orders. And then finally, all those costs that are associated with bylaws, rules, fines, and user fees. We have 2 different kinds of debts that we collect and recover, and this is a really important factor that you learn and separate these early on. Secured debts, these are the only types of amounts that are owned that have been properly passed and authorized that can be included on a lien. So somebody doesn't pay their strata fees, they don't pay their special levy. Those items that can be included on a lien filed in the Land Title Registry against their strata lot. And then we have unsecured debts. So these are debts that cannot be included in a lien. And they often relate to things like damages, bylaw violations, insurance deductibles, these types of costs associated. They're not lienable, but there are other ways to collect them. Secured debts fall into a category that generally requires the strata to collect the fee where the debt can be included against a lien on the strata lot. That part's fairly simple. Filing of the lien is something strata corporations will do when they retain a lawyer who deals generally with collections for stratas to file the lien on their behalf. The costs of the lien, the filing of the lien, and the removal of the lien are all become part of the lien against the strata lot and recovered by the corporation. The Strata Property Act from sections 112 to 118 sets out fairly clearly the conditions for the collection of secured debts. And these are the procedures to apply to court even for an order for sale of a strata lot. Ultimately, somebody hasn't paid their special levy or their strata fees. The strata has a duty to collect them. They will proceed to the courts with respect to a collection order for an order for sale of the strata lot. Here's the things that we get to include on secured debts. So these are the types of items that may be included on a lien: strata fees and special levies, interest if it's permitted either in the bylaws or as part of a special levy, administrative costs. These are going to be legal costs generally for the process of filing the lien form cost, land title costs, and removal of the lien. Special levies that are generated by an insurance deductible against the strata corporation. You've had a massive water failure, of which I hope never happens to anyone, but it does, and the deductible is $100,000. The strata corporation can decide, A, do we pay it out of our contingency, which could deplete the contingency, or B, the strata council can generate automatically a special levy against all strata lots, and each strata lot based on unit entitlement will have a levy due to pay for the deductible of the corporation. Judgments against the strata corporation, the CRT or the Human Rights Tribunal or the courts order damages be paid by the corporation. They may form part of a lien against the strata lots as a share to be paid by each unit owner. And then orders under 8045, which are orders by local governments, the province, an authority who's ordering very specific work to be done or completed. If the owner fails to meet those obligations, the strata corporation with reasonable notice can do the work, and subsequently they can lien for those amounts. Unsecured debts. These are common fees that are not included in a lien. And the reason for this is these are allegations that somebody has done something wrong. You may have a bylaw enforcement damage or insurance claim, but we don't have a judgment that confirms, in fact, that their error has occurred. But one benefit of a lien filed on a strata lot is it takes priority over other charges, such as mortgages. So in the event that there is an application to the courts to settle a special levy and the amount has to be paid out, if it's a lienable amount that the application has been made for, the lien takes priority over the mortgage. The strata corporation is paid out first. However, on unsecured debts, even if you get a judgment, you can register the judgment on title. This could be a judgment through the tribunal, could be an arbitration, could be a court order. If you get a judgment for the amount, you can register that on the title of the unit, but it will not take priority over the mortgages on the properties or any other items that have been registered earlier. So fines for bylaw or rule violations. These are common unsecured debts. User fees. We have EV charging. We have extra parking spaces. We have storage lockers. We have club fees for some recreational facilities. All of these types of things are unsecured debts. Insurance deductibles and damages. Again, these are allegations of what somebody has done. They're not an approved collection or authorized debt that's owed by the corporation. Until you have a judgment, again, these remain unsecured debts. And even when you get a judgment for them and registered, the debts follow after a mortgage has been filed or other charges that were previously filed against the strata lot. And then costs associated with alteration agreements are also unsecured debts. Someone's been allowed to install a heat pump. They've been allowed to make an alteration to a window or a balcony, or they've installed an EV charging station. Any one of these alterations may come with costs or agreements for the operating and maintenance costs of these units. These again would become unsecured debts as you move forward. So understanding the type of debt impacts our ability to collect different things. So the type of fees that we have and how we collect them is really the issue, and as we're going through this and how it gets established. So we look at all of this list: strata fees, special levies, interest, fines, insurance, damage deductibles, user fees. There's a pretty long list. And essentially, I think the key error most strata corporations make, and management companies, when they're doing statements for each owner, they don't segregate all of these separate fees and charges, and it becomes very muddy and difficult when a collection process starts. Strata fees, they're calculated from the annual budget and the contribution to the contingency. They're based on unit entitlement, or if an amendment was filed in the Land Title Registry by unanimous resolution, that changed the unit entitlement to a different schedule. They're the operating budget of strata fees and your contingency contributions, and they're due and payable in accordance with your bylaws of the strata corporation. Always look closely at your bylaws to determine what the schedule and the time period is for the due. One of the benefits that strata corporations often miss out on is that late payment to strata fees can incur a rate of interest. The rate of interest can be 10% per annum, but you need a bylaw that permits this in order to be able to collect the interest. The interest becomes part of the debt owing for the strata fees, and it is lienable. Special levies, except for an insurance deductible paid by the corporation, the special levies have to be approved by a 3/4 vote resolution at either an annual or special general meeting, or if you had a waiver of notice where every owner agrees to the resolution and they waive notice of the meeting, a waiver of notice of a meeting. In that case, everyone must agree in writing, however. Funds levied and accounted separately from the annual budget. When you have special levies, they are not included in your annual budget. They are never transferred into the annual budget. They are never accounted for in the annual budget or operating expenses. They must be accounted for separately, and the principal reason for this is any amounts not used, there may be a surplus where someone is entitled to, or the owners are entitled to refunds, or if there's any interest generated or earned, it becomes a part of and goes back into that fund. Special levy requirements are fairly straightforward. It's a 3/4 vote approval at a meeting. Purpose of the levy has to be identified. The method of how the fee is shared has to be attached. The amount and the date payable by each strata lot. And in a special levy resolution, you can apply an interest penalty if you don't have an interest bylaw. So here's an opportunity to do this. So here's an example of a special levy: $100,000 roof replacement. The purpose of the levy, the roofing replacement. The amount is $100,000 by special levy. The method is unit entitlement. There's a schedule attached. The date of the payment due, here's a little caution for everyone: do not make the date and payment due upon passing of the resolution. There's a 7-day waiting period under the Act, which allows a strata corporation or a group of owners by petition to reconsider the resolution. You don't want to have a situation where everybody is suddenly put into arrears while you're having a reconsideration of a meeting. Give yourself at least 10 days, if not longer. And oftentimes owners are much more amenable to approving a special levy if the levy payments are spread out over a longer period of time. If you are going to charge interest on the special levy, either it goes into the resolution or you may already have it as part of your bylaws. And then another condition you might want to put into the levy is the authorization in the short term to use contingency funds to pay for the collection of arrears for owners as you go forward for those people who haven't paid their special levies. Interest is generated in the creation of a bylaw or 3/4 part of a special levy. It can apply to either strata fees or special levies. The limit is permitted is 10% annually. The limit, the interest may only be compounded annually, and it may only be calculated monthly. So it's really not that much when you think about it. If your annual strata fees are, for a unit, are $500, the annual interest might be $50 at 10% divided by 12, works out to about $4.50 per unit per month. It doesn't seem like that much, but when you're dealing with interest collecting month after month and special levies, it is a substantial penalty for owners. For rules and fines, you must follow Section 135 of the Act. Before a fine or a penalty is imposed, you have to give proper notice of the complaint, the particulars of the complaint. The person is entitled to an opportunity for a hearing or to respond to a request in writing. You go through this process after you've satisfied the entire process, after they've had the ability to respond in writing or to request a complaint. Then the council makes a decision about whether they're going to fine or not. Those fines become part of the records of the strata minutes. Record keeping when it comes to collections is absolutely critical. So the frequency and the rate of fines that you can decide upon are set in the standard bylaws, but as you know, you may amend them. A standard bylaw limit is $50, but you can amend bylaw violations to $200. Short-term accommodation violations can be amended to $1,000 per day, and rules can go from a minimum of $10 to a maximum of $50. The frequency that you can impose fines is once every 7 days for repeat contraventions. So there's a bylaw that prohibits pets, and somebody has too many pets, and they're not getting rid of them. Once every 7 days, you may impose a fine. However, you may also have a serial situation where there are separate events, and this has to do with things like behavior in an erratic way. On Sunday night, somebody has a party, it's loud noise. On Wednesday night, they have another party. Each one of those is a separate bylaw complaint. Each one of them is separate notice. Each one of them is a potential fine. The same applies to the late payment of strata fees. If you're fining for the late payment of strata fees, the late payment on strata fees as a penalty is also a bylaw violation. You must also give proper notice of the delay and the potential fine, so they have the ability to complain. A very common practice tip that we recommend all strata corporations maintain: make sure you have a documentation of your notices of bylaw complaints and the decisions of your councils. If you eventually go to the CRT to collect fines and penalties, or if the owner or tenant challenges them, you're going to require this documentation to verify that you followed the process. Insurance deductibles and damages. So section 158 permits the strata to commence an action if an owner is responsible for an insurance deductible. That's the broad outline of how this works. However, it does require more detailed information. Likewise, under section 133, if an owner is responsible for damages, the strata has the ability to do whatever is reasonably necessary to remedy the damage and to recover the costs paid by the owner. A very common complaint about damages like this is when someone uses a barbecue too close to the exterior of a building, causing damage to the building. It's common property. The strata corporation remedies the damage to the building. They remedy the problem, and they can recover the cost against the owner. User fees, again, they need to be reasonable. Their use and enjoyment of common property or common facilities, and they're under regulation 6.9. User fees may be in rules or they may be in bylaws. If they're in bylaws, then you require a 3/4 vote at a general meeting to amend the bylaw for user fees. If the user fee is in the rules, then it's a majority vote to amend the rules, which is a much easier method, and it doesn't require a filing in land titles, but you do have to post the rules annually to ensure that when you've made these changes, everyone is aware of what they're going to be. The cost of registering a lien under section 118, provided what you are filing for are those items we can file a lien for, the cost of registering and removing a lien can be added to the certificate of the lien. $500 for strata fees, $175 for registering the lien, and the cost for removing the lien. The reasonable legal and land title costs can be recovered as part of the lien. When somebody doesn't pay their strata fees and the strata is forced to file a lien, they can anticipate it's going to cost them another $300 to $500 to pay this amount and get the lien removed. Judgments against the corporation, and these are decisions awarding damages. They could potentially be from the contingency reserve fund, or they could be a special levy of those identified parties. But the issue you want to be careful of is that you're not making, either from the contingency or special levy, a person who the damages were awarded to also paying for those damages. They must be separated from this, and it's from those parties who are identified who pay the damages. If an authority orders a strata lot or an owner to perform work on a strata lot, this occurs where an owner fails to perform the work that's necessary. These could be structural repairs. These could be unauthorized alterations to a strata lot causing risks or damages to the building. The order could come from the fire department. The order could come from the municipality. What you do want, however, is an authority to sign a document ordering the owner and the strata corporation to fulfill these obligations. Alteration agreements, and again, subject to agreements to alterations, and we know in talking about this through sessions that there are limitations, but these are alterations to the common property, limited common property, structure of the building. The strata corporation can make an owner responsible for the costs associated with alterations. These fees are really important that you collect these, especially that they're documented, and when there are transactions that occur, that the fees are up to date, the user fees have been collected. So here are examples when applied correctly, will help your strata with court actions. Bylaws are absolutely essential. Different types of bylaws that deal with things like voting and council eligibility and interest, they all help with collections. Resolutions, ensuring that your resolutions, especially special levies, are properly drafted, will give you and your property manager and your lawyer the authority they need to proceed with collections if necessary. Special levy resolutions that omit critical information can be almost impossible to collect until they've been corrected. Filing of liens against strata lots who have not paid for their special levies, strata fees, lienable items, definitely another collection tool. The real estate form, the Form F payment certificate, which identifies if a person owes any money. This is another method of collecting the fees. However, not always a surefire method based upon when the person requested the fee or who is actually doing the transfer. It could be a bank foreclosure. And higher penalties. So take your bylaws and amend the standard bylaws from $50 to $200 per violation. You need to look at all of these as enforcement tools for the corporation. Ineligibility for voting on strata council. This is a bylaw. All of these are triggered by the phrase, if a strata corporation is entitled to file the lien against a strata lot. And this can have a number of effects. This can affect their voting eligibility at general meetings, and this applies to majority and 3/4 votes only. So an 80% vote for a wind-up or unanimous vote for a change to the strata plan is not affected by this. Or the election to council, or to continue to remain on council. This part I always find a little bit dodgy though, because I frequently will discover with significant special levies that there may be council members who have not paid their special levy, but demand notices were not issued to those council members, still leaving them eligible to be on council unfairly, with other owners being affected as well. Being ineligible to vote is a significant incentive to pay fees, and understandably, people do get in financial hardships. There's no question. An owner having financial difficulties who keeps in communication with the strata council and tries to resolve the problem is probably not going to find themselves on the wrong side of collections, provided they can meet some payments. But an owner who ignores the strata corporation, ignores demand notices, is likely going to find themselves under a collection process fairly quickly. So here's a good example. An owner has not paid their strata fees on March 1st. And a rule of thumb, a real simple rule here is when you send out your notice of your annual meeting, send out your demand notices at the same time, because the demand which makes a strata entitled to file a lien only becomes active after 20 days, the same time period we send out for notice. So March 1st, the strata fee is due. On March 2nd, the strata corporation sends the demand notice of the fee advising if it's not paid within 20 days, the strata may be entitled to file lien against the strata lot. And it's 20 days because of the 14 days notice of clear notice, the 4 days for the different methods of delivery, plus the 2 delivery days is 20 days notice. Now the strata is entitled to file a lien. So if the AGM was going to be on March 22nd or March 23rd or later, now this bylaw can be applied. If you don't do this, the difficulty is going to be this person is going to be eligible to vote, and don't compromise the voting rights unless you have very clear documentation to do this. The rate of interest, it is 10%. It can be charged for late payment of fees and special levies. It's calculated monthly, compounded annually, and automatically added to the monthly fees that are owing, like strata fees, special levies, and can be included in the lien. It is not a bylaw violation, does not require notice, does not require a hearing. Common question on collection for insurance deductibles is, do we need an insurance bylaw? While Section 158 provides the authority to proceed with the collection, between case law, insurance policies, and the different conditions that reside in every strata corporation, we recommend that the strata councils obtain an insurance and damages bylaw drafted by a law firm who routinely does these. You don't necessarily set a higher standard on what the conditions are, but what you do is you set out the terms and conditions of the collection of the debt, of the obligation of the owner required to pay the amounts. The difficulty with insurance deductibles, and you can now do this also, within the tribunal, is that you can obtain an order for a deductible, but if you don't have a bylaw, it's going to become difficult for the adjudicator, whoever is doing this, to be able to make a decision ultimately on the application of the insurance deductible. One of the cautions is, don't impose a higher standard. Don't impose a standard that, for example, requires nuisance to be proved. It's much more difficult, and it is much more difficult for the corporation to collect the deductible. Basic bylaw amendments to rules and fines. The maximum fine for rules is $50. Maximum fine for bylaws is $200. Maximum for short-term, like Airbnb, is $1,000. And then look closely at the frequency. If the strata fee is due monthly, obviously the frequency of a penalty will be monthly. If the violation occurs on an ongoing basis, and you've already had a hearing with respect to the violation, someone's parked a boat in their parking space and is not removing it, the strata corporation may continue to impose fines. The civil resolution is a really great tool to be used for collections of fines and penalties. It's a majority vote decision of council. Before you make an application to the tribunal, the council, the corporation, has to give 2 weeks written notice of the amount owing, that they intend on filing a CRT complaint and for the amount. And ultimately, if a CRT action, once you get a judgment, is filed again, can be filed against the strata lot. But the CRT action cannot be used for an order for sale proceeding for unpaid strata fees or special levies. Unpaid strata fees and special levies require a Supreme Court application. So don't get the two of them confused. There can be a situation, however, with significant costs, such as an insurance deductible, let's say of $100,000, where the strata corporation has received a judgment. They filed the judgment against the strata lot. At this point, if the strata lot owner doesn't pay, they may have to return to Supreme Court to get an order, a compliance order, which ultimately could lead to an order for sale proceeding for the insurance deductible. The difficulty with this is it will not take priority over mortgages. The Form F is, I think, a very good tool. The Form F is used when somebody transfers, remortgages, refinances, there's a conveyance, they've sold their strata lot. And it's really a great tool for outstanding fees and fines and penalties and judgments of strata-lots that haven't been satisfied. Remember, we have a 2-year limitation period on collections, and there's a fair amount of flexibility around this. So when a strata corporation is dealing with collections and you're getting close to the 2-year period, I always recommend legal services to ensure that you've met the requirements and the conditions of the Limitation Act. But the Form F can't be used for collection of damages or insurance deductibles. You need to get a judgment first in the tribunal or in the courts or through an arbitration, but the tribunal will be your quickest option. You need to get a judgment for insurance deductibles or damages and register the judgment on the strata lot. Then you can actually include that amount on a Form F. The other item around a Form F is we always want to detail the expenses. Form F payment certificate can include unpaid strata fees, special levies, interest that's owing, fines, user fees, the costs of registering a lien, and judgments against a strata lot. You must provide a Form F on requested within 1 week, stating either no money is owing or money is owing and paid into court or to the strata corporation, or that it is arrangements made satisfactory to the corporation. One of the challenges with a Form F is it's valid for 60 days. So when an owner may request it, let's say on November 1st, a Form F is provided, they sell their unit in December. At the point of sale of their unit and conveyance in December, they don't require an additional Form F. So you have to be vigilant as to what happens with the time cycles. The maximum fee that can be charged for a Form F is $15, which is a little unfortunate because the amount of work that goes into verifying no money is owing generally is going to take a lot more than $15 worth of labor. It is a collection tool, but it does have limitations. Form Fs can also be, like Form B information certificates, strata corporations can also permit rush fees. And this is unfortunately common in our industry when an agent or a lawyer or a notary at the last minute gets the request to be able to put in for a Form F or a Form B. Within the time window, the only obligation of the corporation or the management company for the corporation is to provide it within 7 days. If someone wants it earlier, a higher fee may be charged. If you're permitting a higher fee either through your user agreement with your management company or in your strata corporation, Strata Council needs to ratify what those fees are. A financial statement is absolutely essential for strata corporations. You need to look at the different kind of costs, whether it's secure debts, unsecured debts, and you need to detail closely all kinds of items on a monthly basis. We account for strata fees and contributions to the contingency fund on a monthly basis. And for small strata corporations, quarterly financial reports are frequent, and that's fine. But look at some sort of tracking system. I've used a simple chart on this guide. This is for the purpose of identifying the different fees. So if you go across the top, the first column is just basically identifies the strata lot number. Second column identifies the infraction date of the fee that's owing. The third column shows that it's a strata fee. The fourth column calculates interest, and on a monthly basis, you can see it's not very much interest. Fifth column shows whether it's a levy. Next column shows, sorry, I can't see the header because of the Zoom headers, but the fifth column next shows penalties. Then we have items that may be an insurance deductible, legal and administrative costs, and then finally, of course, the date of which this item occurred and where it was recorded in the council minutes. A monthly tracking system like this will be worth gold for your property manager, will be worth everything for the lawyer who has to do a collection process for you. The fees have to be segregated. You can't include non-lienable fees on a lien or in an order for sale proceeding. And it's very helpful to be able to track all of these fees as you move along. When owners don't pay, so here's the collection process, right? We understand now all the different kinds of fees and the methods. But when owners don't pay, you want to make sure that you're active, that you treat everybody fairly, and that you have a positive action for the recovery of the debt. So step one, you instantly send out a demand notice for lienable items. For things like bylaw violations, damages, insurance deductibles, you send a complaint notice, and you may send out a statement of the amount owing at the same time. The step two is, if the person hasn't paid and they haven't made arrangements, you file the lien. Don't delay. For some reason, we hear frequently where strata councils are instructed, well, you won't file a lien unless somebody's 6 months in arrears. Absolutely wrong. Don't let it go past 1 or 2 months, because it's just going to become much more of a chronic issue unless you've been in communication with the owner and made arrangements that are satisfactory. If these are bylaw violations, damages, insurance items, you need to impose fines. If that's what your intention is, and you need to start a collection process for those fines. And then the third step is the recovery of the debt. If these are lienable items, or if it's a large amount like an insurance deductible, or there's excessive numbers of fines, oftentimes notice to the mortgage provider can satisfy the debt without having to an order for sale proceeding. Use your legal services. They will contact the mortgage providers, and they'll be able to negotiate these oftentimes much quicker. And then, of course, the last item is when it's necessary, you do have to go for an application to the courts. You know, a year's worth of strata fees, somebody hasn't paid, we're going to make an application, is way too long to wait. 3 to 6 months, you're actively into a collection process. Now, if your strata corporation is a small bare land where your strata fees are $25 a month, there's probably no value in doing it. But when half a year's worth of strata fees and special levies and everything mount up, that somebody owes $5,000 to $7,000, it's totally important to do this. Everybody else is paying their fees. Why are you not proceeding with a collection? That doesn't happen. You know, you have to really look at the sequence and the procedures, and it's important that you go through a little checklist. Always make sure that you have a clearly defined due date in a special levy. When is that levy due? If it's ambiguous, or if it's one of these levy statements that says on passing the fee is due, the special levy is due and payable, you're going to have challenges collecting the special levies. The other problem with not collecting fees, especially for special levies for projects, if you can't collect 10 or 15% of the fees, your corporation can't pay its bills, and you're going to be in a significant enough situation where it may stall or cancel contracts or have cost overruns. So schedule your projects in such a way that your special levy could be due in 30 days. Your project doesn't start for 60 or 90 days. When that occurs, anybody who's been in arrears, the strata has a very active collection process. You know, we look at the date the levy is due, December 1st. December 2nd, there's absolutely no reason to avoid issuing a demand notice to every strata lot who hasn't paid the levy, just to put them on notice that you will be entitled to file a lien within the 20-day period. That's absolutely critical, because nothing can happen until you've started the demand notice cycle. December 25th, we have a council meeting. There are still 3 units in arrears, and the council instructs the manager to charge the rate of interest and to have the lawyers start filing of liens and to give notice of a collection process. The lawyers will manage this. It's a fairly routine process, I'm sorry to say, but it's going to be necessary and the duty of the strata council to collect all of the fees associated. Here's a challenge when you include items on a lien that are non-lienable items. You end up with difficulties with legal costs being recovered. The court may find that the lien was invalid. Your application can be dismissed, it can be delayed, you can incur all kinds of costs. So it's a reminder that accounting is absolutely critical. Your demand notice should include the details separately of strata fees, special levies, the cost of filing, the interest set out in the bylaws. And then by doing that, you've detailed that the costs that you're charging or collecting are only those that are permitted. Another item to think about, of course, is that an owner may want to dispute some of the items that you're claiming, they pay the amount of money into trust to the strata corporation, in which case you have to hold it in trust. You cannot add it to a Form F or proceed with the collection process on it until the matter has actually been resolved in the tribunal or the courts. Remember, the Limitation Act really compels parties to collect on debts. It's narrow now. It's 2 years. And it's especially important for things like damages and insurance deductibles and fines and penalties, where a court action might be your only option. If you still have items owing on the books from 2019 or 2017, you seriously need to find ways of writing them off as bad debts. Odds are you're not going to be collecting them at this time in history. Another issue I think everybody needs to remember on collections is we don't continue to fine month after month after month. Fines are intended to change behavior. But if behavior doesn't change, your next action is to get into the tribunal. Don't wait for 6 months because somebody has a pet that isn't permitted. After 30 days, 45 or 60 days, give them notice of a tribunal action and go to the tribunal to seek an order to comply with the bylaws and to remove the pet and to recover the fines. If you rack up $20,000 worth of fines against this person, it's very likely they're going to be dismissed by the tribunal. Here we go back to the whole part about whether somebody has disputes that are claimed, and they're going to dispute the amount that you've claimed. I think an important part about this, which strata councils fail to meet, you must hold the funds separately in trust until the dispute is resolved. There was a claim that an owner caused $15,000 in damages. They want to sell their unit. They pay the amount in trust to the strata corporation pending the dispute being resolved. They start a CRT claim. They can sell their unit. Once the CRT has made a decision, then ultimately either the strata corporation is going to be granted the damages, or the strata corporation must pay the amount back to the owner who had filed the claim. If you get money in trust and it needs to be stipulated in trust, it's very important that you maintain that amount separately from your operating account, contingency account, and special levy account. You would report that on your financial statements at year end as an amount held in trust pending a dispute. Simple best practices to just go right back to the beginning. Record keeping showing all of your debts separately for owing for each strata lot. It's absolutely essential. I really don't know how strata corporations fairly and effectively collect fees without basically a schedule of arrears and an accounts receivable owing. You must give written communication to all owners of debts that are owing. You can't just create debts and then send them a statement without notice or justification. If somebody's been late in paying strata fees, if there's a bylaw fine, an allegation of an insurance deductible, you must provide written notice, comply with Section 135 of the Act on Bylaw Enforcement. The notice period for demands is full 20 days. It is not 14 days. You give them written notice, they have 20 days in that time period. If you're making minutes about collections or bylaw violations or court for sale proceedings, show the decisions in your council meetings to ensure that your property manager and your lawyer have the authority to take the action necessary. You have special wording, specific wording of special levies in an annual general meeting. That exact wording needs to go into the minutes of your meetings so you have an accurate record of what was decided and what you can enforce. Adopt bylaws that support collections, bylaws for interest, bylaws for voting eligibility or council eligibility. And then, of course, the final thing is make sure you have legal services to support collections, liens and court-ordered sales of strata lots. These are all absolutely critical as you go forward. Thank you. I think we got in through that in about 45 minutes. Daryl, do we have any good juicy questions?
Oh, we actually have a few questions. One of them, I think, just going back to that special levy due date and payable date. So we know that strata corporations have done this where they they impose a special levy on November 30th, but the payment dates are December and January 1st. And so what are the problems or challenges with doing that?
So there's two ways you can do this. The first way you can do due dates is just have a single due date for each strata lot share. So we have the meeting tonight, November 7th, and the special levy is due and payable on December 1st. That's one way. Another method is to spread out the payments if you don't need the funds immediately, which gives a bit of relaxation to the owners. So we're going to say in the resolution that the payment will be divided into 3 equal parts, due on December 1st, January 1st, and February 1st. And the Act actually makes a provision for this, including if the unit is sold, that the payments due by the owner, while whoever the owner is at the time the payment is due, will sell their units, or the new buyer owes the balance of the payments. Either method can work quite well. If you're wanting to give the owners some flexibility, but you're wanting to fix a date for the payment so you don't have to deal with different owners on payments, then a single payment is often a better option. So tonight's meeting, December 1st, the amount is due and payable. The contract is signed to begin the middle of January. Usually, in most cases, 80 or 90% of their people pay their special levies right up front. And that's not an issue. So you have lots of cash flow, which also gives you time for units that haven't paid their special levies if you have to start collection proceedings on the legal front. And that itself, of course, might take 30 to 90 days to get that process fully evolved. So, think about your cash flow needs as well as you go forward.
And then also remember that you have that, like, don't make your special levy due on the date of the meeting that is due. Give that time for a challenge if needed.
Well, the difficulty with making it due and payable is under Section 51 of the Act, they can have a reconsideration of the vote, and everybody says, well, that never happens. I've seen that happen 5 times already that I know of this year, where the special levy was reconsidered. There was a new notice of a meeting that was issued, and 2 out of those 5 times, the special levy was defeated. Not saying that was a good thing, but that is what the Act makes available for a provision. And so it really created an accounting nightmare for the Strata Corporation, because in part they'd collected a bunch of money from owners, but the people who were opposed, the money had to be refunded. Then there were disputes over interest. Avoid making your special levy due and payable on passing. It's not, the other problem with that, it's not a date. If you want your special levy due and payable on November 8th, then say the special levy is due and payable on November 8th. Don't make it due and payable on the day of the special general meeting if today is the special general meeting.
Good question here. Can a section file a lien independent of the Strata Corporation, and can sections apply to the Supreme Court to order the sale of a unit?
So it's the Strata Corporation. This is a complicated problem, which requires the involvement of the Strata Corporation as well, right? So there is a collection proceeding requirement, and there is an order for sale proceeding requirement. So yes, technically, yes, is the answer, but it's complicated because it also involves the Strata Corporation when you're dealing with this. So the recommendation is to use legal services who can basically filter through the collection debts that are owed by both the corporation and the section to ensure that there is no crossover or misinformation in them. Because frequently what happens is the accounting of both parts can get muddled, and it creates problems. But if it's just the section who is filing the lien, who is filing the notice and the application to the courts, it is possible. But again, use legal services so both the corporation and the section are represented and involved.
Super. Special levy insurance deductibles, do they require approval of the owners?
So if there is a special levy of the corporation, so we had a good example is a building in Kitsilano not long ago, they had a riser that failed. The riser flooded out 18 floors and stairwells and several units. No one was at fault. It's $100,000 deductible of the corporation. The Strata Council can automatically levy the owners for that deductible without the need of a 3/4 vote. It does not require a 3/4 vote, but they need to word or have the special levy worded to match section 108 of the act. That includes due date, the purpose, the payment schedule, all of those items. And then the Strata Corporation essentially pays for the deductible that way. It is actually can be beneficial under some circumstances because it will permit owners individually to use their insurance deductibles to pay their portion of a special levy for that deductible. So that can actually be beneficial for the corporation and the owners. The difficulty with with insurance deductibles coming from the contingency fund is they really bleed the funds and the resources.
So can you explain some brief examples of acceptable arrangements to pay monies owing when an owner owes a secured debt, for example?
Well, somebody gets 1 or 2 months behind in payments, and they in strata fees, they've gone to council and says, I'm so sorry, I lost my job, but my new job starts on December 1st. I should be caught up by December 15th. Strata council can say to them, that's fine. We are going to charge you the rate of interest in accordance with the bylaws. That's fair. Everybody pays it. But we won't file a lien. However, if by December 16th you haven't paid the amount, the demand notice that we've issued will stand and a lien will be filed against your strata lot. So, short windows of time where there can be agreements. We have people who investors from outside of the country who take time to transfer funds into the country to pay for fees and levies. Those can take 21 days or more. A little flexibility can be reasonable. But whatever you do, at some point when you're going to issue demand notices and file liens, do the same for everybody. Don't treat some people differently than others. You might not send out the demand notice the day after the due date. You might wait 30 days and then send out the demand notice. And that might actually get you a lot more people paying their levies. The benefit of the demand notice is it enables you to take further action. It doesn't impose a cost on the owners. It's a communication that goes from the property manager or from the Strata Corporation directly, but it does enable further action. If you don't send the demand notice, you don't have any of that activation occurring. It doesn't mean you have to file a lien, but it means you are in a position to file a lien.
Yeah, and I guess so. It also allows that communication that you were talking about to happen between the owner in arrears and the Strata Corporation, and then it would also so that should be in writing though between the parties.
It must be in writing. And here's another little rule. Make sure your owner list's contacts, addresses, and emails are up to date and that you're sending it to the correct identified address, because that could also be a little bit of a fly in the ointment of all this process.
Great. I think that's it.
Super. Thank you, everyone. Much appreciated that you joined. Again, if you have any feedback, we try to make this a basics course. But if you think there was something specifically that could add more information without making it longer, I'd love to hear the feedback from everybody. So much appreciated everybody's participation. Thanks so much.